You know, every once in a while, the Supreme Court throws down a decision that makes everybody in the Second Amendment community sit up and pay attention. And this week, we got exactly that. Out of nowhere, they dropped an emergency ruling, 8-1, that directly shakes the whole debate over these so-called Second Amendment Preservation Acts. Now, if you're new to this fight, SAPA laws are those measures states pass when they're tired of federal overreach and decide to draw a line in the sand. Missouri kicked off the biggest one, but other states have been watching closely. And when the highest court in the land suddenly steps in with an almost unanimous decision, that's not background noise. That's the kind of move that can change the entire battlefield. Think about it. We're not just talking about lawyers filing motions in some courthouse. We're talking about a real clash between state sovereignty and federal authority over your gun rights. For folks like us who grew up around firearms and understand that the Second Amendment isn't a privilege, but a safeguard, this is more than legal paperwork. This is about whether states can actually shield their citizens from Washington's ever-growing reach. So, in today's breakdown, we're going to take this apart piece by piece. Look at what the court just said, why that 8-1 margin matters, and most importantly, what it could mean for you, me, and every other American who cares about keeping their rights intact. Let's set the table properly here, because this fight didn't just come out of nowhere. Back in 2021, Missouri passed what they called the Second Amendment Preservation Act, or SAPA. On paper, it was only a few pages of legal text. But in reality, it was like throwing a rock into a hornet's nest. The law basically told Washington, if you push federal gun control beyond what we believe the Constitution allows, don't expect our cops, our courts, or our state agencies to play along. That's bold. That's Missouri telling the federal government, we're not your enforcers. Now, why does this matter so much? Because for decades, the balance of power between states and the federal government has been this constant tug-of-war. The 10th Amendment gives states the right to govern themselves in areas not explicitly given to Washington, but the Supremacy Clause says federal law is the supreme law of the land, so SAPA is really a collision point between those two ideas. This isn't the first time we've seen states try something like this. Think about immigration sanctuary cities. Places like San Francisco told the federal government they weren't going to use local police to enforce federal immigration laws. Or think back to the marijuana debate. Colorado legalized cannabis, even though it was still federally banned. Did that stop the feds from enforcing the law? No, but it made enforcement extremely difficult because without local cooperation, the federal government is basically fighting with one hand tied behind its back. Missouri saw that playbook and said, why not do the same thing for gun rights? And the timing was no accident. After years of federal pushes for new gun restrictions, pro-Second Amendment lawmakers in Missouri wanted to draw a line in the sand. For them, SAPA wasn't just about one law, it was about making a statement that the Second Amendment is not negotiable. And here's where the drama ramps up. The Biden administration, along with the Justice Department, immediately filed lawsuits. They argued that SAPA was flat-out unconstitutional. Their reasoning was simple. Under the Supremacy Clause, no state can pass a law that overrides federal authority. If they allowed Missouri to get away with this, what's to stop Texas or Kentucky or Montana from doing the exact same thing? From Washington's point of view, that's chaos. But from the state's perspective, this wasn't chaos, it was sovereignty. Missouri argued they weren't blocking the feds from enforcing their own laws, they were just refusing to participate. They said, if federal agents want to come in and enforce something, fine, but you won't use our sheriffs, our courts, or our taxpayer dollars to do it. And that distinction matters, because if Missouri could hold the line, it would set a precedent. Other states like Oklahoma, Arkansas, maybe even Florida, would feel emboldened to pass their own versions of SAPA. That's why this one state law suddenly carried national implications. So by the time the lawsuits landed on the desks of the Supreme Court, it wasn't just Missouri versus Washington. It was a test case for the entire country. A test of whether states could really push back against federal gun control by drawing on their 10th Amendment powers. And let me tell you, folks in the gun community were watching this closely. Because if Missouri pulled it off, it would have been the biggest win for state-level Second Amendment rights we've seen in decades. When the Supreme Court finally stepped in, the hammer dropped hard. The justices issued what's called an emergency decision, and it wasn't even close, 8-1. That kind of split tells you a lot. This wasn't a case of fine print or a 50-50 toss-up. It was the court making a loud, unified statement. So, what did they actually say? In plain terms, the court ruled that Missouri can't block federal agents from enforcing federal gun laws inside the state. The Supremacy Clause gives the federal government the authority to enforce its own statutes, and no state can outright cancel that. Now, here's where the nuance kicks in. The justices didn't say the Second Amendment itself was weakened. They didn't declare federal gun restrictions constitutional or unconstitutional. They weren't ruling on what the laws are, but on who gets to enforce them. That's a crucial difference a lot of headlines missed. Think of it this way. Missouri can't slam the door in the face of federal agents, but the state can choose not to help. That might sound small, but in practice, it's huge, because law enforcement is about resources. Without local sheriffs, deputies, and courts backing them up, the feds are limited to their own manpower, and in a country this large, they simply don't have the boots on the ground to cover every county. We've seen this same dynamic play out in other battles. Look back at Prohibition in the 1920s. Alcohol was federally banned, but states and localities that refused to cooperate turned enforcement into a game of whack-a-mole. Or take marijuana in modern times. Federally illegal. But when Colorado and California stopped cooperating, the federal government could only scratch the surface. Enforcement without local buy-in is a logistical nightmare. That's why, even though the court struck down Missouri's SAPA in this form, it doesn't mean the concept is dead. Far from it. It means states now know exactly where the line is, and you can bet legislators are already drafting new versions of SAPA-style laws that thread the needle. Laws that stop short of blocking federal agents, but still refuse to provide state support. And let's not ignore the political weight of that 8-1 split. When you've got conservative and liberal justices agreeing, it signals to every lower court in the land. Don't waste time fighting this on the same grounds. It sets the precedent in stone. But at the same time, it also lights a fire under pro-Second Amendment lawmakers to find new creative approaches. So the takeaway isn't just SAPA lost. The takeaway is that the battlefield has shifted. Now it's about strategy, how states can withhold cooperation without crossing the line the Supreme Court just drew. And in that sense, this 8-1 ruling isn't an ending. It's the opening chapter of the next round in this fight. Here's where the shockwaves really start spreading. A Supreme Court ruling doesn't just stay inside a courtroom. It ripples out into politics, campaigns, and even the way you and I experience our rights day to day. On the political side, both camps wasted no time seizing this decision. Federal officials are already holding it up like a trophy, saying, "See, even the Supreme Court agrees states can't stand in our way." That's their narrative. But on the flip side, pro-Second Amendment lawmakers are flipping that same ruling around, saying, "Fine. Now we know the exact boundary lines, so let's redraw our strategies and push back smarter." And that's what makes this so powerful. In states like Texas, Kentucky, and Montana, this decision will actually fuel lawmakers to go harder. You'll see bills that look different from Missouri's SAPA, but chase the same goal: limiting federal reach without crossing that constitutional tripwire the court just flagged. Politicians will campaign on it, governors will sign it, and grassroots gun rights groups will use it to energize their base. Let's be real. This fight isn't happening in a vacuum. We're in a political climate where the Second Amendment is one of the most polarizing issues on the ballot. One side frames it as common sense safety. The other side sees it as a direct assault on freedom. And this ruling just handed both sides fresh talking points for 2024 and beyond. But here's the part that matters most to you and me as gun owners. Laws on paper are one thing. Enforcement on the ground is another. If state and local officials decide not to prioritize federal gun rules, then in practice, your rights look very different depending on where you live. The AR in your safe, the mags you run at the range, even the way you buy ammo, all of that is influenced less by Washington, D.C., and more by what your state is willing to enforce. And that's why staying engaged matters. This decision should be a wake-up call for the gun community. You can't sit back and assume the courts will protect your rights automatically. Courts draw the rules of the chessboard, but it's up to us, voters, gun owners, grassroots activists, to decide how the game actually gets played. That means showing up at the ballot box, supporting pro-Second Amendment legislators, and keeping the pressure on at the state level. Here's my personal take. This 8-1 ruling isn't a defeat for the Second Amendment. It's a roadmap. It tells us exactly where the court is willing to draw the line, and it dares states to innovate within those lines. If enough states take up that challenge, the feds are going to find themselves outnumbered and overextended, no matter what the law books say. Because at the end of the day, the real question isn't just what the Constitution says. It's whether your kids and grandkids will grow up with the same rights you had, whether they'll be able to walk into a gun store and exercise those rights without Washington breathing down their necks. That's the legacy this fight is really about. At the end of the day, this Supreme Court decision is just one more battle in a much bigger war over the Second Amendment. Missouri may have taken a hit, but the fight is far from over. States will adapt, lawmakers will adjust, and the gun community isn't backing down anytime soon. That's why staying informed matters. The court can set the rules, but it's up to us, gun owners, voters, and patriots, to decide how those rules play out in real life. And you better believe we'll keep watching, breaking it down, and giving you the straight story every step of the way. Make sure you like, subscribe, and drop a comment down below. Stay sharp.